Welcome. I'm Ada Kay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. Why is it that happened to me? Dang nabbit. I caught it. Welcome, everybody. Replay. Hope y'all are doing well. Oh my God, grab your cup of coffee. I got my new Rodecaster Pro in, and I forgot that I have to unprogram the auto mute because when you're done with the show, it automatically mutes. And I forgot about the features. In a minute, I'll deprogram that. That I forgot about that, y'all. It's a wonderful device, but sometimes it's smarter than I am. Yes, it is. So I'm excited to have it. My sound hopefully is crisper, clear, and easier to hear. I don't feel like I have to yell and turn the volume up or down. It depends. So the new machine is in and installed. Okay. So yeah, I forgot about the auto mute. So what I said was yesterday we had day 3 of Jose Antonio Soto-Escalera trial. And then we had the Donna Adelson motion hearing deep dive. You want to hear what's going on with this and the crap she is throwing at the walls? Watch it. It's interesting. I did a really good dive, I think, for someone who's not a lawyer. So here is my recap of day 3 in this trial before we get started. There we go. The key points from yesterday were this. The transcript conversation read. The prosecution presented a transcript that was translated from Spanish to English of a conversation between Soto-Escalera and his nephew, in their work truck. In it, Soto-Escalera allegedly discussed his plans to put this red drum his lover, including how to dispose of the evidence and her remains. Surveillance footage from neighbors, Catherine Scott, testified regarding her home security for total 2 front, 2 back, which were operating on the night in question. The footage. I've been up for an hour and a half and I'm still yawning. The footage captured in the car driving by her residence at 8:25 p.m., which aligns with the timeline under the prosecution's investigation. Scott also confirmed that she provided a raw video to law enforcement and testified that the footage had not been. Okay, proximity of location. Detective Christopher Newman provided testimony about the physical distance, the victim's home from the address of 2086, blah, blah, I don't, which figured into the evidence in context. The translation and interpretation expert testimony. Understand, there was a huge battle yesterday and late in the afternoon, the day before, that was Tuesday and Wednesday, over whether this evidence would come in. After hearing the evidence, I understand why the fight was so fierce. So Nora Campos, an FBI language specialist, linguistic, spoke about her role in translating and transcribing Spanish audio relevant in this case. Some of the content in the transcript included threats allegedly made by Soto-Escalera towards Wise. I'm going to bang her brains out if she doesn't talk. I'm being careful with words. I have no choice. I'll lose everything. And discussions of dumping the body, making evidence, and masking the evidence, and hiding the evidence, and whether to use a driver or not. It was a full-blown conversation on multiple days and levels. The defense cross-examination highlighted portions of the audio hard to hear due to the background noise or unintelligibly. And Campos said only clearly audio parts were translated. So she translated only what she knew to be true and clear. She didn't guess. She didn't, take a stab at it. So another neighbor, Tamara Carino, another neighbor testified about her. We can turn the volume down. From her yard and driveway in the night in question. Thank you very much. I don't know why I'm going in and out. Maybe I need to pull closer. Is that better? Thank you, Tracy. Is this better? We'll try this. I don't know why I'm going in and out. It may be the microphone. I may have to replace a cable. We fix one thing, then other things start going. So that is where we ended our day yesterday. Is this better? Hold on. Is that better? We'll see. Okay. It's amazing when you fix one thing, sometimes other things start falling and you're like, no. Oh yeah, I know. Oh, good. Thank you. Hey, June. Love you, boo. There is a volume control, I think. Let me look at my volume control. You can turn the volume up and down a little bit on. That's that better. Is that a test? For y'all who don't know, when my mod needs to get my attention, she blows the whistle on me. It is a way for when I have a bunch of documents in front of me, I can't see the StreamYard, and I can't tell when there's a problem. Yes, that was a test of the National Horn System. So anyway, much better, June. That nearly knocked me off my chair. That would not have been fun in any way, shape, or form. So anyway, We are ready to get into court. They are ready for court. Let's go. They are bringing the jury.
All right. Good morning once again, ladies and gentlemen of the jury.
I need a volume check.
As you're aware, it's my custom at the beginning of every court session to re-advise you the most important principle of a fair trial is that you, the jury, judge the case only on the official evidence presented in court and nothing else. So continue not to talk about the case or the issues or the people involved in the case with anyone, including your fellow jurors. Don't do any research in any form whatsoever, and avoid all media coverage of the case in any form whatsoever. We continue with the state's case, and the state may call its next witness.
We call Elizabeth Bedola.
Mama.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Hand over to the witness here.
And you may inquire of the witness.
Good morning.
Good morning.
If you could just state your full name and spell your last name.
It's Elizabeth Bedolla, Bedolla.
Okay, and you are Tanya's mother, correct?
That's correct.
I want to show you what's been marked for identification. States Exhibit 146. Do you recognize this?
Yes,
I don't recognize that photograph.
she's my daughter.
Okay, and is that your daughter from when she was alive?
Yeah.
This time the state would move into evidence what's been marked for identification as States Exhibit 146.
No objection.
That item will come into evidence without objection.
And at this time the state will just publish what is marked or entered now as States Exhibit 146. Thank you, ma'am. I don't have any other questions.
Any questions from the defense?
No, Your Honor.
Thank you. You may step down. And the state's next witness or item of evidence.
Yes, sir. People say before I call Rose Rosario.
While we're waiting, don't forget to get your bingo card. It is pinned at the top of your comment. While we're waiting for the clock, here is our bingo card.
The truth, the whole truth, and nothing but the truth, please? Thank you.
Over that way to witness.
Everybody has that weird voice.
And you may inquire of the witness.
Morning.
Good morning.
Can you state your name for the record and spell your last name, please?
Yes, Rose Rosario, Rosario.
Okay. And Ms. Rosario, what do you do for a living?
I am a interpreter, translator, transcriber, practitioner.
Okay. Go ahead and give the jury a thumbnail sketch of your education, your training, and your experience, please.
Yes, good morning. I was trained by the Uruguayan Air Force. I was a diplomat interpreter, translator, and transcriber. Later, I started working in 2004 with homicide units for the 19th Circuit Court, and then with the 17th Circuit Court, doing transcriptions and translation.
And where is the 17th Circuit?
17th Circuit is in Broward,
Broward County?
the Broward courts, yes.
Okay. I didn't mean to cut you off. Go ahead.
No problem. I got my certification in 2012. as a transcriber, translator, practitioner. And I've been working the field close to 21 years.
Okay. And just some background questions. Where did you grow up?
I grew up, I was born in Cuba. I came when I was in the second grade, so I was raised in Hialeah, Miami area.
Okay. And were you raised in a home where Spanish was the primary language?
Yes.
Okay.
Yes, it was.
And did you learn English? Obviously, you know English, right?
Mhm, yes.
Okay. And how well do you know Spanish? It's obvious, but how well do you know Spanish?
Oh, very well. My parents made sure that the Spanish language was not lost when we started school. So we had to take Spanish lessons all the way from elementary to high school.
Okay. And did your parents, did they only speak Spanish or were they able to learn English as well?
No, they learned English. They were nurses, so they
Okay.
learned English.
Okay, good. And did you have any formal education in Spanish?
No, not formally, just the one that you take in school, advanced Spanish. And Spanish was always spoken in the at home.
Okay.
And then I married into a Spanish home also.
Okay. And you said that you worked for the Uruguayan Air Force?
Yes.
Okay, go ahead and describe that experience for the jury.
Okay, I worked as a diplomat, interpreter, translator, and transcriber.
Are you
So,
having difficulty hearing the witness? You could keep your voice up. and
oh,
move.
I'm sorry. Okay, at the Uruguayan Air Force, I was trained as a diplomat, interpreter. I was the interpreter for the assistant air attaché. So we did all the interpreting for all the foreigners, vendors that came to the office. I translated everything that was done in that office was received in Spanish and had to be translated into English. And then with the vendors, it had to be translated back from the English into the Spanish to give back the responses to the Uruguayan Air Force. It was your purchasing office.
Okay. And you did that for how many years?
5 years.
40 hours a week?
Yes.
Okay. And from that point forward, where did you go and what did you do as it relates to to Spanish and Spanish translation and interpretation?
I started, let's see, in 2004. I went back, I got away from the interpreting field for a little bit. I did real estate. Then in 2004, I got back again into the interpreting field. And I started working with 19th Circuit Court, doing the transcribing for jail calls, confessions, everything pertaining to homicide cases.
Okay. And go ahead and you mentioned that you had obtained a certification.
Yes.
Can you explain that to the jury, please?
Yes. In 2012, I got a professional certification for the transcribing. It's called transcribing translator practitioner. And by that time, I already had acquired about 5,000 hours of transcribing and translating for the Uruguayan Air Force. From 2008 to the present, I've acquired 4,500 hours in homicide cases for translating and transcribing.
Okay. And to be clear, the primary language of Uruguay is Spanish.
Yes.
Okay. And describe the transcription process for the jury. Tell the jury about that.
Okay. First, we get the sound file or the audio files. We listen to it. You have to listen to it several times before you start transcribing so that you can get familiar with the voice, the speech pattern, the volume. Once you hear it a couple of times, then you start the transcribing process. the transcribing process is done before you start the translating part. Once you have that, if you take a look at the format, you have a column that's in Spanish and a column that's in English. So once all the transcription is done, it gets proofed. We proof it to make sure that we've got everything down that was transcribed. After that portion is done, then we start with the translating part.
Okay. And let me ask you this. Is there a difference between translation on one hand versus interpretation on the other?
Yes,
Okay.
yes.
Explain that distinction to the jury,
Okay.
please.
So the interpreters interpret orally. The translators, we do documentation, word documentation. Everything that's in the written form, it's a translator versus the interpreter, which does oral.
Okay. So as a practical matter, is there a big distinction between the two? Describe the distinction in practical terms to the jury.
Yes, there's a big distinction. It's two different professions. Sometimes there are translators that also do.
Okay, I am going to correct her here. Not to be rude. She has no formal training or degree in this. I do. Interpreter is ASL English. I'm taking an English, Spanish, or any spoken language. And I'm taking it from that and putting it into a conceptual language, i.e. sign language, whether it's ASL, written, Mexican, Vietnamese sign. That is how that works. Translation is English to Spanish, Vietnamese to Spanish, one language to a next language. Okay. Transliterating is when you're taking something that is spoken and put written form or written form into spoken. So transliterating is when you take something from a text form into a spoken. I understand what she's trying to say here, but I just want to make sure we're correct. Some people may argue that. Go ahead. I have a degree in this. I'm not trying to boast that my expertise, but I just hate when someone gets in court. And I think she's doing the best that she can do in describing this because that's how it was taught to her. So that's why I'm a stickler. I'm an interpreter. She is translation. Who's doing transliterating? Okay, got off my soapbox. Had to say it.
Interpreting, and the same way interpreters that do translator, but it's a different field. Interpreters go in and out. They interpret on the fly. Translators have more time to work with the document. We're able to research and go over and over again the document or the files that we're working with.
Okay. So, and again, to put it in practical terms, let's say I were to call a witness who only spoke Spanish. Would you be the person to interpret that to the jury, or would you not do that?
No, that would be an interpreter.
Okay. So to be clear, what you're doing is translation. You're not doing interpreting.
Correct.
Okay. Okay. Thank you. Okay. And were you provided some evidence in this case, the state of Florida versus Jose Soto-Escalera?
We were provided with sound files and videos.
So I'm going to show you what has been marked as State's Exhibit number 169. Do you recognize this?
Yes.
Okay. What is that?
This is the denoised audio video, about 11 hours long.
Okay.
Then we worked on.
Is that an external hard drive that contains the audio and video and all the materials you reviewed in order to arrive at your conclusion in this case?
Yes.
Okay. And did you translate the August 24th, 2018 video and audio from a Waste Pro garbage truck?
Yes.
Is that what's on there?
Yes.
Okay.
Yes.
And did you reduce your findings to a written transcript?
Yes.
Okay. And does that transcript reflect what you listen to when you listen to exhibit number 169?
Yes. Mhm.
Okay. And Your Honor, permission to publish using the same procedure we did yesterday.
You can ask the witness questions about content of sections of the item.
He's referring to having another person come in to read.
Oh, okay,
Yeah.
yeah, but in that form, yes, you
Yeah,
may do that.
okay.
Okay.
We're going to go get Mr. Blanc. And while we're doing that, tell the jury how many hours that you spent on exhibit number 169 and arriving at your conclusions.
Okay. Like I said, it was an 11-hour video. We spent close to 110 hours, between 110 to 150 hours working on the videos.
Okay. Okay. Over a period of how many weeks or months?
About 2 months, 2 to 3 months. Because the way you do this, you can't work on these more than 5 hours. It's too exhausting. So we do sessions of 4 to 5 hours tops.
Okay. And okay. Here's Blanc.
So
Do you have a copy of your transcription?
You can use it.
Well, Your Honor.
Okay, so Ms. Rosario,
Mhm.
can you, we'll start off on page 1. And Mr. Belanca will play the role of the individual that can be more audible. Ms. Rosario, you will play the role of the individual that is less audible. Does that make sense? As we described in my office?
Yes.
Okay, okay, so we'll go ahead and start on page 1. Ms. Rosario.
Know what's crazy? All these gloves are,
Throw all that out.
it's garbage.
Inaudible.
Where the hell is the ox tape at?
That's in the bag. Oh, Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it later. That I would have, unintelligible.
Well,
You can't be mad at people.
huh?
You can't be mad at the people.
Yep.
We can throw it in there.
Put on the gloves.
Okay.
Objection, Judge.
Yes.
That's interesting.
Line 20. You follow me, Ms. Rosario?
Yes.
Okay, line 20, go ahead and read all of that particular section, please.
Okay. We can throw it in there. Put on the gloves.
Line 21.
Okay. The ones of that black.
baby girl, hold it together. The woman next door.
We can throw it in there. Put on the gloves.
The ones of that black?
Yeah, stay with those. Don't let, because they have my prints. Pretend that so that nobody sees you. Sure, it's good. Right here, bro.
Just open the door.
We can throw it out in the España.
Inaudible. Almost there. Inaudible.
Can back up. We'll do it inside, man. It's best. It would be good with trash. If it don't work out, okay.
Back and forth. Back and forth through there. It's coming.
Take it out of the bag. Put on the gloves. Take it out that I'm going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro.
Yeah, ain't nothing outside.
That was incorrect. You need to go back. As far as who speaks the line, correct? Sure.
I'm trying to figure out if anybody knows why Facebook will not allow live to be live. It only goes live when I'm done going live. Used to not do that. Weird.
Jury, let me ask you to step back into the jury room for a moment so we can sort this out. We'll be with you momentarily. Please leave your notes in your chairs and do not discuss the case.
Hello, Judith Frog. Hello, everybody. Hello, Miss Deborah. Yeah.
All right, we'll go off the record as the transcript is being highlighted to avoid the wrong parts being spoken. Go off the record momentarily.
He does the body. Oh, good. I am drinking a cup of my famous Tudor Shack coffee from the Hitchman homestead. I have Colombian dark roast this morning. It is so good, y'all. I wish we had taste of vision. They get their stuff.
Read it. The prosecutors. I think we.
Okay. Ooh, nice red jacket, my dear. Not very many people in court today. I love how the officer's been on his phone most of the time.
Is not present. All parties present.
13. There is an MV3. So we can I'll defer to council. We can skip it or delete it, or we can have Rose Rosario read it.
I think we just skip it.
No, I want there's
Yeah,
a
we'll-
third person in the
We'll have Rose
translation,
Rosario read it.
but she needs to make certain that it's a different person.
Right.
So I don't know how you're going to accomplish that, but
You could,
She'll say it.
one of the prosecutors could read that line.
agree with that
Yeah.
Okay, yeah.
methodology.
Before you do though, before we get started, we'll go back from the beginning, reread the whole thing.
Yeah.
And if you want to just clarify through the witness that at some point there's a third voice,
Mhm.
and that will be stated by whoever's going to state that.
Right.
You're still doing the highlighting? Okay, take your time.
So I'm being told I'm breaking up when I talk. Am I breaking up right now? It may be only when let me know if I'm breaking up when I'm talking over the video or when I'm solo. Because right now this is called solo, and I'm kind of giving a test of the sound. And then it may be when I'm talking over the video. So just let me know. I will go ahead. I'll have to order me. I can get one of these cords, but they're crappy. I'm going to order me a really good replacement cord for the microphone. That probably is. The conflict may be when the video's running and having to.
Back on the record, this is for the lawyers. All parties are present. Have I ever told the jury that the transcript will not go back into evidence? I don't believe I have. I think I should,
Yes, sir.
because they're going to ask for it. Just to be sure that
Yes.
this is just being used to assist putting the evidence on. The evidence is the testimony, not the transcript. The transcript will not be available, so they could take notes.
Yes, sir.
Okay.
Yeah.
So I will do that as well before you get started.
I'll clarify both transcripts.
What's that?
I will clarify both transcripts for the one yesterday as well as today. If that would be okay.
What do you mean? I'm going to instruct them on.
No, yeah,
That's
but
what I
we
mean.
didn't- we didn't
Neither
tell them
transcript
yesterday.
is
Yeah,
going to go back,
yeah.
not just this one.
Right.
Yeah.
Okay. Still doing the highlighting. Okay.
That's true. Yeah.
I'll have those 3 lines right now.
We go some more. I am. Anybody good with Facebook? For the longest time, my lives I could do on Facebook, and you can see them. But there was things that to go in my lives on Facebook Live. Any of you are Facebook friends of mine? Please go on Facebook.
Give me 1 second.
Why am I going in and out? Oh, the video's still going. I bet it happens when the video is going. Now the video is not going. Am I going in and out now? I asked if I'm struggling with Facebook. I used to be able to go live on Facebook while I was live on YouTube. No problem. Could do it simultaneously. All of a sudden, boom, something changed, and it will post in my Facebook only when my live is over. Rain.
All right, back on the record, jury is not present. There was another issue.
Yeah, yes, sir.
Abstain.
If you'll take a look at page 3, and it's line 37. Let me know when you're there.
Mhm.
Ms. Rosario, can you please explain, if you take a look at page 3, line 37, and just tell the judge what you told me about page 3, line 37.
Okay, so, on page 3, the box 37, they stepped out of the truck, so we were not able to see who was the person speaking. I just transcribed the conversation as I heard it without designating anyone because I wasn't able to see who was doing the talk.
From the reading, as we cannot attribute it to what we're now calling the closer participant and the further away participant.
No objection.
All right, so you're both agreeing just not to read that.
Correct. Yes, yes, sir.
Third entry 37. Okay, that's fine. Otherwise ready for the jury? They're still doing the highlighting?
Yeah,
Okay.
lots of boxes here, sorry.
Mm-hmm. off the record momentarily.
I'm done with the Facebook thing. It's just not working. I'm just going to have to wait. I was hoping I had somebody who wanted to watch live, and I was hoping to get it up and
Reading MV3.
The two individuals step out of the garbage truck and they cannot determine
Correct.
who the speaker is.
Just off the record, Mr. Richardson said no one's reading MV3, and that's not accurate. The state's going to read MV3
I'm gonna read
on the other
MV3 on
page.
page 30.
Okay.
Yeah,
Correct.
I thought you were talking about the one that
37.
we
No one's
deleted.
reading
That he's
37.
reading.
Correct.
Yeah.
No, off the record momentarily. All right, let's bring the jury in. I'm going to tell them we're going back to the start. I'm going to tell them about the transcripts not being evidence, the evidence being what's said in court, and give them instructions on that to assist them in deciding whether to take notes.
I just re-signed into my account. I hope, like, oh my God, do not disconnect the live. I was panicked for a minute. Still off. Yeah. Hello, Miss Evan E. Good morning. Good morning to you.
There was some slight mishaps, which is going to cause.
Okay, I don't know why they're doing all this.
All right, ladies and gentlemen of the jury, in the witness and the conduit witness, as I refer to it, reading the evidence, there was some slight mishaps, which is going to cause us to go back to the beginning. You should know the testimony in this regard is going to be much shorter than the one you experienced previously. Also, I wanted to tell you before we get started, too, as I've mentioned, it's up to you to decide whether or not to take notes. But in making your decision, I think you should know this information. With regard to the translation evidence, which is what we're doing here, the evidence is what is being said in court here. The transcripts themselves that the witnesses are using to do that are not evidence pursuant to law and will not be available to you during deliberations. So please be aware of that. You should know, though, too, during deliberations, should you need to, you do have the ability to re-listen to the testimony, to be brought back into the courtroom, and I would replay the testimony to you. You would have to hear the testimony in its entirety unless we were to determine otherwise, but that is the default legal position. So I just tell you that in your decision whether to take notes. And as I mentioned before, disregard what you heard previously because there are some slight errors in it. We're going to go back, the state's going to go back and restart the testimony in that regard. And you may do so, Mr. Richardson.
Yes, sir. Thank you. And Mr. Zari, before we begin, are parts of this also in English that the speakers are using? Are they using a mixture of Spanish and English, or is it completely Spanish?
Sometimes it's in Spanish, sometimes they use what we call Spanglish, which is a word that it's anglicized, or they switch code, which is they speak in a sentence in English and Spanish.
Okay. And a few more questions. Are you familiar with Spanish that's like variations of Spanish, like Puerto Rican?
Yes.
Okay. Explain briefly to the jury your experience with Spanish derived from Puerto Rico.
Okay. Although I was raised in a Cuban family, my husband, whom I was married to for 25 years, is Puerto Rican.
Okay. Do you have any trouble or difficulty understanding Puerto Rican?
No.
Puerto Rican Spanish?
No,
Okay.
the regionalisms, no.
Okay. All right. So now we're going to start again, and we're going to start on page 1.
Mhm.
And we're going to start with line.
The other part, whether Mr. Cormier is going to be assisting what's going on there.
Yes, Ms. Rosario, is it your understanding that Mr. Cormier, is there a third participant within this particular item of evidence?
Yes.
Okay, explain that to the jury.
Yes, there's a third participant, which is when they get to the weight station and the guy that's doing the weights, the scales and all.
I'll just give a very brief explanation of why someone else is speaking. Without
getting into what you saw and what you heard, just why is there a third party there?
Because they get to the weight station and
just as far as the voices heard and why there's a third speaker, just focus on that, not with regard to what's going on in the context.
we designate a voice number for everyone, for every speaker that we hear. So number 3 would be that person.
Number 3, again, is an unknown party.
Correct.
Okay, gotcha. Okay, so we'll go ahead and start.
Okay. Know what's crazy? All these gloves are inaudible.
Throw all that out.
It's garbage.
Inaudible.
Inaudible. Where the hell is the aux tape at?
That's in the bag. Oh, Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it later. That I should have, I would have. Inaudible.
Well,
You can't be mad at people.
huh?
You can't be mad at people.
Yep. We can throw it in there. Put on the gloves.
The ones of that
Yeah.
black?
Yeah. Stay with those. Don't let, because they have my prints. I'll pretend that nobody so that nobody sees you. Sure, it's good right here, bro.
Just open the door.
We can throw it out in the España.
Inaudible. Almost there. Inaudible.
Can back up. You know, we'll do it inside, man. It's best. It would be good in with trash. If it don't work out, okay.
Back and forth. Back and forth. Through there. It's coming.
Take it out of the bag. Put on the gloves. Take it out that I am going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro. Yeah, ain't nothing outside.
Up to there is good.
Put it on the floor then.
Huh?
Put it on the floor.
If there are many cars, forget it. Go back.
Don't look that way. I'll tell you, inaudible. Ready to come inside?
Here. You don't have any messages or anything like that
Where?
of hers online.
Threatening her or something like that?
No,
No, none of that.
no, no.
There's none of that.
Inaudible. No, inaudible.
Let me go see something. I did inaudible things. Good.
I could have done it alone.
Huh?
I could have done it.
You know why I showed my face? So that they don't assume.
Take the right. Where the hell are you going, bro?
When I get home, I have to go check it right there. You know what I need from you? Keep me occupied so I don't think. I was talking to a policeman friend of mine about things like this. He says it is not proof of anything. It is inaudible standard. That is not
Yeah.
like a revolver that leaves prints.
As soon as I walk in, all she looks at me and she says, inaudible. Somebody else. Inaudible. 6:45, bro. And don't call.
I left at the house 5:05 on top of the fucking pad.
Huh? Telephone call. Hello? Hey?
I have to go to the house. Got to go to my house right now. You hear me? Got to get something. Yeah.
Telephone conversation. I'm on the road. Inaudible. Can't get to inaudible. Oh, that's what I'm saying. I'm on the road.
Is she still at the house?
Huh?
At her house?
She's leaving. She told me she would like inaudible. Oh, God.
Well, I'll see you at the house because I have 4 cartridges bags on top of the pickup truck there that match the cassettes.
Where are you going to pick it up?
Now, move, dump that, go to the house. Should I tell Mike, inaudible, I'm driving and my wallet I left at home?
Can't be fucking. You can't think too much. You can't be back and forth because that's how you get caught.
That's tough.
You gotta act calmer.
Yeah, the auxiliary port cord. It's there in that bag.
Huh?
The auxiliary, I'm saying the wire.
I had it there, right there. This part here. You put it in.
Hold on a second.
Do we have another side, Bob?
Mr. Rosario, can you please restate number 72 on page 5?
Yes. I had it here, right here, this part here. You put in the output and this little thing. You just put it, I put it right there and it all stays.
It's rolled up in that little black thing. You'll see it. It's in the top zipper. Where are you at? You're in the wrong place. There, right there. Should be wrapped up in a little black inaudible.
Inaudible.
I'll do it. Tell me what it is saying.
Welcome, right there. Inaudible, right there, inaudible. Main road,
Already dropped the kids off?
inaudible. Did she have any money yesterday?
Huh?
She didn't have any money on her?
I didn't have time for that.
She didn't have money?
I don't know. Why?
Was asking. I should have went.
I think it.
Man, they're killing their beat, bro.
Why?
They went through his road.
No, he didn't.
Yes, he did. Inaudible.
Who's the driver?
Johnny.
That means he's in there then, right?
I just wish they had a male transcriber because, oh my God, listening to this woman speak. Yeah, bro. It just gets me a little giggled. I'm envisioning him and them sitting in the truck or wherever speaking, and I'm hearing this woman voice, and it just got, yeah, bro.
Oh shit, that's a Waze Pro truck.
Yeah, put some like Aventura, like Bashada shit like that. Go on. Do you have some Romeo?
Huh?
Romeo Santos?
Santos? What kind of bullshit is that one? Definitely dirty.
That's inaudible dad.
Huh?
His dad.
Where?
In that yellow inaudible GTO.
Ah, my head keeps on hurting.
Inaudible.
Inaudible.
What time is it?
8 something. 8:16.
Let's see what the fuck he said.
Who? You wanted to go. Inaudible, right?
No.
Yawns out loud. Inaudible. You got one more.
Huh?
Inaudible. Up front.
Huh?
Inaudible.
I want to do it when I get out of here.
Inaudible.
Huh?
No man can be happy. Oh, that's all I need.
What?
I'm totally fucked.
Do you have water in there?
Inaudible.
Huh?
Inaudible. Something burnt?
Put something Traviano.
One's life, bro.
I need a fucking drink.
What are you going to do with this?
I have food.
You're gonna eat salad? We're here.
Get me a drink. My fucking mouth is dry.
Huh?
My mouth is dry. Did you hear me? Can you grab me a Monster or a Gatorade?
What?
Hey, inside.
You wanna inaudible?
Huh?
Ain't it?
Huh?
Inaudible.
Who?
You.
An orange one?
Inaudible.
Good.
Now you know how I feel when I get no sleep. I get dehydrated the next day.
It's hot out.
Eat this. Inaudible. The dehydrate will go away.
I like when inaudible.
If you eat this, you get hydrated.
You don't want to eat it? The last one? Fuck
Right, what do you eat that will hydrate you?
you, bro.
Nasty.
Want a sandwich? Hey, want to put your music on? Tastes good, right? Fuck that sandwich up. Rice and beans with ham?
Not yet. Why don't you turn it on? Hey, this bitch is bad enough. Inaudible. Lip syncing. Like right there.
There?
Lip syncing. What happened, bro? You're falling asleep.
I'm falling asleep. I'm going to take a 30-minute break. You have to put the one of inaudible Gil. Put on the heavy music.
Lip syncing.
Do you know how I feel now? Like in a beer mode. I'm thinking crazy, I know. I'm going to have to feel as if I'm going out on a bank, bro. I'm inaudible if I have to. Can't do that though. Inaudible.
Can't do that too. Inaudible. Because I have to be calm like that now. Everything to them. It's fine.
Did she have a purse? Hers? No. If they find her now, they can't do the inaudible final because the mom is not called. She is not missing yet on this side. They don't consider her as missing. The what did she die of? What did she have? What does she have? So they will put her in a box, take her out the sun, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths when I got to her house, and I bathed this morning. I bathed. I cleaned my hands with the cleaner, the one for breaks, because I had gloves and everything just in case.
Did you see the blood?
Huh?
Did you see blood? Did you see?
I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag.
Inaudible.
Exactly. What's for dinner tonight, bro?
Huh?
What's for dinner tonight? I'm thinking pizza. You know, I can't go to that street no more.
Which, that one?
By that street.
You're confused with the streets like that.
By there no more with this truck. They can watch me also with that.
This is a work truck, man.
Huh?
This is a work truck. Inaudible.
Right. Did you make the landfill? Inaudible. Everything?
I hope so.
Inaudible. I want to move forward and get out of this mess. You got to run through this side right here. It's bigger. Inaudible.
Inaudible.
Hold that. Hold on so I don't lose it.
Lip syncing.
You said there should be one over here?
Huh?
Huh? There should be one over here?
Nothing there.
Huh?
Nothing there. Inaudible. Bro, look at her hair. Laughs out loud.
Watch there. From the back.
Inaudible.
Who?
I'm starving, man.
We'll get a little piece of food. I have to put my plate back of that. I'm going to put it there. The plate, put it back.
Of your car?
I took it off. The one that says Puerto Rico, I took it off. I have to put it back on. Do you smell that burnt shit?
Huh?
Smell it. What is that?
I don't know.
You smell it though, right?
Yeah, keep your eye on it. Can be your battery. Did it start otherwise right? Keep your eye on it. Radio still working?
Yes, sir. Thank you. He waved at us and everything.
He said it audible. Inaudible.
Huh?
Inaudible.
He waved at us. Nice and easy.
All right. What do you feel like cooking tonight?
I don't know.
All right, look.
That's probably what it is.
What?
The batteries. Thank you.
Okay, Ms. Rosario. To do one more item here. Did you, were there portions of these videos and audios that were more difficult and less difficult to hear? Were more of them audible and some of them unaudible, or what? Can you explain that to the jury?
Yes, they were. All this was taking place in a truck, so there was a lot of noise, and he had the radio on also. It was difficult, but doable. We took a lot of time with it.
Okay. I'm going to go ahead and publish, give the article. I'm going to go ahead and publish a part of it. And if you could translate that portion, and if you need to refresh your recollection with the transcript. Does that make sense?
Yes.
And for the record, the portion that we're going to start on is page 10, line 167 at 5 hours, 59 minutes, and 48 seconds. Mr. Rosario, you ready?
I'm sorry, could you repeat the portion, the
So
section?
we're going to go to page 10,
Mm-hmm,
line number 167.
okay.
Mr. Rosario, if you could refresh your recollection and tell the jury what was said at that particular portion.
On that side, on that portion, he was saying, no, if they find her now, they can't do then it was inaudible. Final, because the mom has not called, she's not missing yet. On the side, they don't consider her as missing. The what did she die of? What did she have? What does she have? So they will put her in a box, take out the son, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths. When I got to her house and I bathed, this morning I bathed, I cleaned my hands with a cleaner, the one for breaks, because I had gloves and everything just in case. Did you see the blood? Huh? Did you see the blood? Did you see? I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag. Exactly. What's for dinner tonight, bro? Huh? What's for dinner tonight? I'm thinking pizza. I think that's somebody.
Okay, thank you. And to be very clear, the person who said I had it all over the clothes, but without the evidence, they can't do nothing, was that the individual that was easier to hear?
Yes, that was,
The individual is easier.
yes, MV1, yes.
Okay, all right, thank you. Ms. Rosario, I appreciate your participation. I have no further questions. Defense counsel may have some for you, okay?
Cross-examination.
Thank you, Judge. Ma'am, how many times have you testified in court?
This would be about the 7th time.
7 times. How many times of those were for the defense?
I believe a couple of times.
A couple?
Yes,
How many?
2 times.
2 times. Okay. You said that you spent 110 to 150 hours working on what we just heard.
Yes,
How much do you get paid an hour?
$95 an hour.
$95 an hour. Okay. You did a certification for that transcript that you just did, the reading up,
Yes,
is that
yes,
right?
Yes, yes.
Okay, and on your certification, you said pertaining to this case from 8/23/18 is a complete and correct transcript translation from Spanish to English, is that right?
Correct, yes.
Okay, so you certified that this was from 8/23/2018, correct?
Yes.
Okay, no further questions.
Any questions? Further questions from the state?
If you look at your certification, 82318, is that a typographical error?
I don't have the,
If I show you the certification, will that refresh your recollection?
yeah, I mean, if that's what I have. Oh. 824, okay, that's a typo.
Okay. Does the video,
It's a-
go ahead and read the video, title of the video and evidence into the
Yes.
jury, please.
The title is,
I'll sustain the objection. I believe the item that's referred to is not in evidence, so it's asking for the witness to read something that's not in evidence.
Okay. Can you refer, can you tell the jury this title of the
Objection.
Can you- I'm going to show you the electronic copy of the file,
Objection,
From
Judge, do we approve?
Exhibit 169.
Let me, wait for a question. Let me see what the question is. The previous objection was sustained because the witness was being asked to say something to the jury regarding something that's not in evidence. If you're using it to refresh her memory, you need to ask a substantive question. You can assist her in answering the substantive question. She can't ask her a question to read something that's not in evidence. So
Yes, sir.
going forward with that clarification, ask
If I-
another question.
Yes, sir. If I were to show you an electronic copy of the file that you used in arriving at your conclusions, would that refresh your recollection as to the date of the translation, as to the date of the video that of the recording in this case?
yes, it's 824. There was just a typo where I'm referring to pertaining. But the body of the certification has the correct date,
Okay, so
824.
okay, tell the jury again, what is the correct date of the video that you translated?
The correct date for the video is the one I have right on the text.
Raising the objection, you need to answer the question without referring to the document.
Yes, the correct date is 8/24/2018.
Thank you.
Any further cross-examination?
Just briefly, but on the thing that's called a certification, you wrote that the date was 8/23/2018, correct?
That's on the bottom part. On the main text, it has 8/24.
I'm asking on the certification itself, the thing that's called certification. You're looking at it right now. It says 8/23/2018, correct?
That's the second part.
Okay, so we didn't even get that correct, right?
We have, it is correct on the main, what I am, the title that I am certifying
Ma'am,
is
ma'am,
8/24/2018.
permission to approach the witness, Judge? I'm talking about the document entitled certification. This is the document.
Correct.
Okay, lawyer, your attitude is not needed.
And that where the date
Power suit has gone to your head just a wee bit.
is, the certifications is 8/23/2018, correct?
That is not the, that is not the certification. This is a preliminary certification which was emailed because they were in a hurry.
Okay.
To show the judge. This is the final one. And it's got all the information.
Oh, so we got it wrong in the initial one and in that one, correct?
It is not, well, over here on the second part,
It says
it's
8/20.
8/23. But the text, what I am certifying is correct, August 24, 2018.
Okay, but it says 8/23/2018.
Objection.
At the
That's
bottom is a
I'll
typo.
sustain
The
the objection. I think
certification
it's been
is
asked and
24.
answered at this point.
No further
Any
questions.
further questions from the state?
No, sir. Thank you.
May this witness, Mr. Rosario, be released from her subpoena at this time?
Yes, sir.
Any objection to releasing the witness?
No, Your Honor.
You may be released from your subpoena. You're free to stay or leave as you wish. Thank you. You may step down.
I don't like your attitude. Like, really?
And the state's next witness or item of evidence.
Yes, sir. The people state before recall Detective Chris Newman.
Recall. have a recall. Yes, we do.
So you can raise your right hand, basically.
Do you swear affirm that evidence you have
So far, this is what I got. Free to go, audio, unintelligible. Raise your right hand. Transcript, face, objections, authenticate, the evidence. The jury fit.
And during the course of your investigation, did you learn the location of the defendant's residence in August of 2023? Or, I'm
Yes.
sorry, August of 2018.
Yes, sir.
Okay. And what was the location of his residence? What was the street address?
I know it was on Cactus. The exact address escapes me right now.
2613 Southwest Cactus.
Objection,
Okay. Did the defendant live at 2613?
leading.
Does not suggest the answer.
I'll overrule the objection. It's an open-ended question.
Did the defendant live at 2613 Southwest Cactus Circle?
Yes, sir.
Okay. And was a search warrant executed on that residence?
Yes, it was.
On what date?
I believe it was August 28th of 2018.
Okay. And did you recover, did anyone from the sheriff's office who executed that search warrant recover any clothes with blood on them?
No, we did not.
Did you recover any weapon with blood on it?
No, sir.
Okay. And sir, that is all the questions I have. Thank you.
Cross-examination.
No cross.
At this time, may Detective Newman be released, or you wish for him to remain under subpoena?
I wish to ask for a little.
Please step down, Detective. You do remain under subpoena. And the state's next witness or item of evidence.
Premature approach.
Sure.
We have a sidebar, y'all. So, was the transcripts a nothing burger to you? Oh, Lord have mercy. I just need to quit yawning, y'all. I got up this
We're
morning.
going to take a restroom break at this time for 10 minutes. Please do not discuss the case with each other. Leave your notes.
Okay, so let's go over the bingo card a little bit better today. Miss June, if you have anything different, please inform me. I could be wrong. I've been known to be wrong. And I know I'm going to go up to live chat because if there's something different, that's where I put it. I got it, June. Thank you so much. So these are what I have. We have, get my mouse over here. Free to go. Said you were free to go. Audio. I think he said that at least. Raise your right hand. They did do that. An audible. We heard a lot of that. They have transcripts and notes. We have free space. We have objection, Your Honor. We have sustained or overruled. We have truck. Move to evidence. Are you going to move it into evidence? Are we authenticating it? Yep. Bring the jury. Oh, admitted. Those are what I have, love. So I have one bingo. Don't forget to like, subscribe. Don't forget to I liked if you liked. If you're new here and you've never subbed, you do put I subbed. And if you share the live, put I shared. I would greatly appreciate it. It really helps. It really does. This lawyer is trying to insinuate that the state has had this translated to fit their version of events. Yeah, that's kind of what I feel. I kind of feel like that's where they're leaning. Yesterday they were attacking our translators pretty aggressively in arguments. about the quality of translation and that there were some discrepancies. But if you don't understand how translations work, there always is going to be there's always going to be some discrepancies. But what are the discrepancies? So if one says the word was in sign language, I can do this, that's need, but it could have been shoulda, woulda, must. The context of the sentence will dictate the words that I use, but sometimes I may use the word uncomfortable or pain, and he was sad versus he was down, disappointed or not happy. I mean, you're going to have minor differences. We're going to have minor differences, but is the concept still the same? And I think that's what's important now. This a group of people, their transcription is on the whole nother level, man. Most transcriptions are baseline here. They're way up here. I love the way to hear how they did it. They sat there and listened to it. They had it transcribed from audio recording into a Spanish, which is one column. So as you're listening to the audio in Spanish, you're seeing the Spanish transcribed. So you can match the Spanish transcribing from the audio spoken to the written. Then they take the audio form to written form in Spanish. Then they take the Spanish and translate it into the English. And that is where some of your discrepancies hide as well. So, and they only transcribed from Spanish spoken to Spanish writing. That transcription was only done on things that were clearly audible. If it wasn't 100% audible, that's where it they would say intelligible. Can't say it. Unintelligible. Because they're not going to second guess at this. They certified each step, and then, as she stated, they have a final. Because I certified this fully transcribed document for you. So very thorough. I'm always fascinated with this kind of stuff. Yeah, she's got her head on my toesy. I got a footrest underneath my desk, and she's under that, but she got her head on my toesies. I am so sorry. Did the defense get their own? No, they did not. I don't think they did. I love you, boo, but I'm cold. I get my binky. Absolutely adore. It's I like these because it's got some weight to it. Getting comfy and cozy up in here. Winter is going to be fun in here. I'm going to have a heater. It's going to be fun. So, Miss June, how are you doing? Miss Deborah, how are you doing? Nightbot, you're doing good. Don't need to hear from you. Thank you guys, everybody who's joined us today. We really, really appreciate you being here. Thank you so, so very much. So let me get to, they should be coming back shortly. Oh, that's what I need. Oh. Or Nightbot. No one ever wants to hear from it. Oh, we don't mind hearing from it.
Let's bring in the jury if they're ready.
Before we bring that, this is the one that is, this is one of the states exhibits, that's the hard drive, it's 169. 169, we're gonna have it up and open, we're not gonna play from the video, he's gonna play an audio portion, but we're gonna start with this already up. Which, it's in evidence, they can view it, but I'm just making sure if there's any issues beforehand, I want to.
Which one was the 169? Which translator person?
August 24th with the person.
With the one that
What would
was
you-
just
yeah.
testified to. So this is the video and audio portion. You're just playing overlapping portions.
We're
of
not
what-
even playing it. We're just,
Okay.
we opened it where you can see a pic of inside of the
Picture
truck,
of what
and
it
you can
looks
see
like.
some people, someone
Okay.
driving and someone is
It's
passing.
just stills.
This is a video, but it's
Okay.
paused.
Okay.
After they do their identification, we're gonna take it down and then we're gonna play audio.
Okay, my bad. Here's the updated card, Miss June. Thank you, Miss June. Here's the updated card. Hello, it's great. Good morning. Yes, I know. Good night. Please leave your DNA, the Nightbot says. I see, Deborah. Hold on. I got multiple things coming at me at once. I appreciate it, boo. I don't see a message from you. Where did you put the message? Put it in chat. Deborah, where did you put it in Discord? I don't see it in Discord, boo. Where did you put it? Message from you. Are you talking about the one from 8:48 a.m.? I did see that, and I did. But if you sent me something newer, I don't see it. It's there. So anyway, here's all we have left: state rest, video, FBI, closing arguments. Everything else has been checked off. Woohoo! Boy, we're moving through this bingo. Yay!
Agreed is redacted.
Okay.
Perfect.
Yeah. Okay. Very good. Let's bring in the jury.
Bring the jury.
All right. The jury is present, and we proceed with the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida recall Adolfo Cavelli.
My gosh, why are we recycling all these people? You're killing me, dude.
I'm not sure how to spell that last name. I don't remember. I gotta be honest. I don't. Don't remember.
Yes, sir.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes,
sir.
And you may inquire of the witness.
Good morning. Can you state Can you state your name for the record and spell both your first and your last name, please?
Yes, sir. Adolfo Cavelli, Adolfo. Last name Cavelli, Cob as in Victor, Elli.
Okay. and I believe you testified a few days ago. Were you a senior official at the Waste Pro location here in Fort Pierce in August of 2023? Or I'm sorry, August of 2018.
Yes, sir.
Okay. And were you familiar with the trash routes of the drivers in August of 2023?
Yes, sir.
Okay. Were you specifically familiar with the trash route of the defendant, Jose Soto-Escalera?
Yes, sir.
Okay. Did he have a trash route in northern Fort Pierce?
Yes, sir.
Okay. Can you tell the jury what his trash route was?
Yeah. I can't give you the exact every road and all that, but it was in North Fort Pierce, in the Indrio Road area, Johnson Road, Rousseau Road, around the Spanish Lakes area, in northern Fort Pierce, St. Lucie County.
Okay. And can you walk the jury through was there a system in place where each of the employees of the Waste Pro, if they were on a garbage truck, what was their knowledge of the camera and recording system?
Yes, sir. So I was there when we had the cameras installed, and every employee that was in the vehicles had to acknowledge that they were being recorded both by audio and visual recordings.
Okay. So did every employee who was assigned to one of those garbage trucks have specific knowledge that they were recorded?
Yes.
And that they were videotaped?
Yes.
Okay. And how well did you know the defendant, Jose Soto-Escalera?
He was an acquaintance and an employee, like most of the employees. I was very close with them to get to know their families and ask about them. And Jose was one of those people too.
How long do you think you knew him?
I would say backing up from 2018, a few years. I believe Jose worked for us and then left and came back. But regardless, I've known Jose since his employment at Waste Pro.
Did you have many conversations with him?
Yes.
Did you know him it sounds like you knew him in the context of work, is that correct?
Yes.
Did you also know him socially?
Yes. Yes.
Okay. Do you know him well enough to visualize him, identify him?
Yes.
Okay. We're looking here at a freeze frame of one of the videos from exhibit number 169. If you need to, step down, but do you see Jose Soto-Escalera on the smart TV?
Yes.
Okay. Can you identify him? Which one is he?
The gentleman with the glasses and the steering wheel in front of them to the right of us looking to the right.
Okay. And who is the other individual in the vehicle?
I'd like to come up with that.
Sure.
I think they're just tying up their loose ends.
Who is that?
The helper of the route, Eric Alvarado.
Okay. And did you speak to Jose Soto-Escalera enough to recognize his voice?
Yes.
Okay. And based on that familiarity, if I were to play you a clip from an audio of exhibit number 169, would you be able to recognize his voice?
If I hear it, yes.
Okay. Okay, so for the record, we're going to go to page 10, line 167 of the transcript. It will be at 5 hours, 59 minutes, and 48 seconds. I'll stop it right there. Did you hear two voices in that clip?
Yes,
Was one softer and one more audible?
yes,
Okay. And are you familiar also with Eric Alvarado's voice?
yes.
How long had you known Eric Alvarado for?
Since his time of employment, I don't recall exactly how long. It was a shorter time period than Jose Soto.
Had you had multiple conversations with Eric Alvarado?
Yeah, I'd greet the team every single morning, all the employees, yes.
Okay. And can you tell the jury the identity of the individual whose voice was less audible in that clip?
The one that had a lower voice?
Yeah.
Eric Alvarado.
Okay. And can you tell the jury the identity of the individual who had a more clear and more audible voice?
Yes, that would be Jose Soto-Escalera Soto.
Okay, thank you. I'm now going to show you now we're going to publish States 170. Okay. Okay, I'm going to show you a video from August 21st of 2018. Okay, yeah. Yes. Okay. Are you? Can you take a look at those individuals in that one that's working?
Yes,
Okay. Do you recognize who the driver is?
yes.
What's his name?
Jose Soto-Escalera.
And do you recognize who the passenger is?
Yes,
What's his name?
Eric Alvarado.
Thank you. Yeah. We'll go to August 23rd of 2018. Video. Yep. And here we are looking at a video from August 23rd of 2018. Who is the driver?
Jose Soto-Escalera.
And who is the passenger?
Eric Alvarado.
And here we are looking at August 25th of 2018. Who is the passenger?
With the sunshine, do you mind if I walk up, please?
Sure.
Thank you.
What's the identity of the passenger?
The passenger is Eric Alvarado.
And the driver?
Jose Soto-Escalera.
Okay, same question on the video from August the 27th of 2018. Who is the driver
Jose Soto-Escalera,
and who is the passenger?
Eric Alvarado.
Okay. If we could return, we're going to do one more. Audio. Sir, thank you very much. That's all we have left.
Thank you.
Any questions from the defense?
No, you're right.
May Mr. Cavelli be released from his subpoena at this time?
Yes, sir. Okay.
Thank you, Mr. Cavelli. You're released from your subpoena. You're free to stay or leave as you wish.
Thank you very much, sir.
Thank you. And the state's next witness or item about.
Your Honor, at this time, the people said for arrest.
Ladies and gentlemen of the jury, at this time, the state has rested its case. Let me ask you to step back into the jury room for a moment. Please do not discuss the case and leave your notes on your chairs, and we'll be with you momentarily.
The state has rested. Hallelujah. Really? Really? Nobody has told me about this typo in that this whole time. Y'all, I have a typo. Dang it.
All right, the jury has exited the courtroom at this time. The state has rested its case. Any motions from the defense?
No motions from the defense.
Okay, and from the defense, no witnesses other than whether the defendant is going to testify. Do you need time to confer? Sure, confer with the defendant to make a decision whether he wishes to become a witness. I'll inquire of him in that regard, and then we'll go from there. But we'll go off the record, giving the attorneys a chance to speak with the defendant to make that very important decision.
I don't understand why they have not had that done. That should have been discussed. Why is it? Are we pulling another Donna Adelson? Really? Are we pulling a Donna Adelson? This should have been discussed already. So this is bothering me. Ah, that's better. Outside of the jury's presence, I'm going to come here and leave that up for now. We are honoring the 3 who have passed away and 2 officers that were shot yesterday that are still with us. My heart and prayers go out to everybody involved. This is horrible. Those who have been affected, passed away, rest in peace. Those who are in the process of healing. Any comments? Let's see. Thank you so much, June. Let's go over right now. We are 3 away from a coverall. FBI Foundation and closing arguments. It looks like we may get a coverall today. If we get a coverall, everybody gets extra entries. Get a total of 12 entries, plus the coverall makes 13 into the bingo giveaway at the end of the trial. I do bingo giveaways at end of trial. Okay. Oh, my watch told me it's time to get up and move around. Yes, I've been trying to wear my watch, trying to keep in line. Oh, I know. Hello, it's Britt. It is so sad. So very sad. So our hearts and prayers go. I'm getting quite exhausted by the amount of this crap that we've been dealing with. I think it's crap, and I'm thinking I'm having allergies. I think it needs to stop. Stop the violence. That is my thing. This is what I feel about the violence. Yep.
The defendant regarding his decision to become a witness at this time. Mr. Soto-Escalera, you can be seated, but if you raise your right hand, the clerk will swear you just for a brief inquiry from me on that particular point.
You swear affirm that the evidence you're about to deal with be the truth, the whole truth, and nothing but the truth.
Mr. Soto-Escalera, the decision whether to become a witness in the case, unlike most decisions in trial, is personal to you, meaning you receive the advice of counsel, but you make the decision up and above their advice. If there's a disagreement as to whether you should testify, you get to make that call, even if you disagree with your attorney. You have received their counsel. First of all, do you understand the decision is personal to you?
Yes, sir.
Are you deciding to testify or not?
Not, sir.
Not. Are you doing that of your own free will?
Yes, sir.
I will find that you're making the decision not to become a witness freely, knowingly, and voluntarily. Will proceed in that fashion. And therefore, let's discuss the plan. My suggestion is to release the jury till when they come in, have the defense rest, release them till 1 o'clock. We'll do a quick charge conference and give you the remainder of the 2 hours to polish your closing arguments and proceed at 1 o'clock. Is that a good plan?
Hours.
I think the parties might have agreed a different plan, Judge.
Okay. Well, I'm open. I'm open. I'm just, okay. I know we talked about finishing tomorrow too, which is possible. Is that what you had your eyes on?
Yes, sir, if that would be okay with the court. Yeah, Friday works better, if that's okay. We've had a long 3 weeks.
I'm open to that. Of course, the advantage if you do it this afternoon, I realize, I've done your jobs as well. So I realize, what goes into a closing argument. The advantage is if there is a conviction, you get tomorrow off to prepare. There's that too. But either way, is that what you both agreed on?
Yes, sir.
Okay, that's fine with me. All right. So then I would bring in the jury, have the defense rest, and then tell them they're excused for the rest of the day. We'll do closing arguments tomorrow morning.
I do have a suggestion. Judge,
Sure.
and, you can
Close
deny
tomorrow?
it. What?
Rest tomorrow for you.
No. I don't mind resting now. I was just wondering if we could do the charge conference now and charge the jury today. And that way, when we come back tomorrow, we could just go straight into closings and then they deliberate.
You want me to read the instructions to them before your closing arguments?
Yes, sir.
State agree?
Read all the jury instructions before?
Correct. That's
Yes.
the request.
You mean today or tomorrow?
Today.
That way we make good use of the time.
So then what
Yeah.
we would do closing, and then you would remind them and say, I read you the law yesterday.
Yeah, I've never done that, but it's a standard practice with other judges. Nothing wrong with it.
And they're gonna get a copy of it anyways.
Exactly.
I just think that'll give them something to ruminate
Saves us
over
time.
tonight.
I have no problem. It's time efficient for me.
Right.
And I've always wondered why there's not more requests to do that, because they'll know what the law is before you make your arguments as opposed to the other way around.
Exactly.
Okay. And I'll tell them the attorneys have agreed with this procedure. I'm going to instruct you on the law, and then they're going to make their arguments tomorrow. Don't form any definite or fixed opinion at this time. You haven't heard their arguments.
Correct.
Are you going to tell them in the instructions about their ability to review the testimony again? I think the only issue was the way it was said could be interpreted that they have to listen to the whole trial, and that that rule only applies to individual witnesses.
Well, let's do the charge conference now.
Yes, sir.
Do you have my latest?
Yes, sir.
You have my latest email in that regard. I just took out, obviously, the defendant has become a witness. What I have remaining for your consideration, from my perspective, before we go back to the beginning, under weighing the evidence, can I take out, has the witness been convicted of a felony?
Yes, sir.
Because there's no such thing in this case. Okay.
Correct.
And how about, my default position would be to leave it in, but any pressure or threat been used against the witness that affected the truth of the witness's testimony? We could have had that in this case, but I don't think we, is there any of that? Anybody want that?
No, sir.
State?
I couldn't quite hear, I'm sorry.
Has any pressure or threat been used against the witness that affected the truth of the witness's testimony?
Not impressive.
Both sides agree. I'm going to take that out. So now we have in that section 7, with the extras being offered to receive money, which there is, and make an inconsistent statement, which there also is. And all right, so going to the top, any objections to the way I have it? You may, I don't know if you caught this because the last version I sent you, I don't think I alerted you to this, but there was one section I added in, unborn child, where it should be. I don't know if you caught that, but it's there now, and it's proper in one of the unborn child instructions. I think it was actually on page, what should be page 5 for you, lesser included. That last sentence, the lesser included crimes of first-degree murder of an unborn child or second-degree murder of an unborn child and manslaughter of an unborn child. Before it said just second-degree murder or manslaughter, so I just added that in. It's a very slight tweak. You may, if you see that. But so we have introduction, statements of charges, introduction to homicide, justifiable homicide, excusable homicide, first-degree murder as to count 1, count 2, first-degree murder of an unborn child, lesser included crimes, and then second-degree murder, lesser offense as to count 1, manslaughter as to count 1, second-degree murder of an unborn child as to count 2, manslaughter of an unborn child as to count 2, plea of not guilty, reasonable doubt, weighing the evidence, defendant not testifying, defendant's statements, rules for deliberation, cautionary instruction, verdict, single defendant, multiple counts. As to all of that, any objections or suggestions before I get to the part Mr. Cormier mentioned, which is, I'm going to get to that, what I have now. You can see what I have as far as it's the second to last paragraph. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most, but not all, of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine an exhibit in evidence that was not sent back with you into the jury room, please let us know, and we will bring you into the courtroom to do so. That's my standard instruction. I don't touch the issue about rehearing testimony at this time. If they have a note, we do. And what I was alluding to when I spoke to them about that was the default position is to play the entire testimony of those two witnesses, which is the safest, more proper thing to do. I have had it sometimes, and the law does allow, if they specify to us one particular place, you could do that. But in this case, it's going to be extremely difficult. I'm not sure how they would do that unless they were going like section 3 or something like that, as Mr. Richardson was referring to it. You know, if they did that, perhaps there would be an agreement, but otherwise it'd be the default position. And those portions are really not very long anyway. So my default position would be to do that, but it's not addressed in there. So do you want some time to look over what's there and see if you have any objections to it before I actually instruct the jury?
Well, page 2.
Page 2.
Count 2. In element 2, there's just a typo for the name of the defendant. Actually, and also in element 1.
You're saying page 2. I have page 2 is excusable homicide.
So do I.
Oh no, I'm sorry. I'm sorry. Count 2, first degree murder of an unborn child.
So, yeah, it says Soto-Escalera. Soto-Escalera.
Oh,
And I think
that.
it's spelled
Okay,
wrong in the
gotcha.
front.
Yeah, it's spelled wrong in number 1 as well.
It is spelled wrong in the one?
Yes, it's an
E-R-A.
E-R-A.
Oh, okay, gotcha.
And I think in the other count, you had his middle name.
Let me see. Hold on.
And sometimes it has Tanya's middle name, and sometimes it doesn't.
Her middle name or his?
His.
And hers, sometimes she's referred to as Tania Wise, sometimes she's referred to as Tania Esther Wise.
Anyone have a problem if I just get rid of the middle names and we say Jose Soto-Escalera and Tania Wise? Because middle names, like, why are we? It's like a wedding invitation or something, you know.
No objection.
Okay, so I will go ahead and do that. Let me see. Hold on. Let me go ahead and do that. As you're reading over the rest of them, just taking my time and without using control find, just going through it. So don't make any other.
So what we're going to do is, when this is done, we're going to go over to the drugged husband red room trial we started yesterday, and we will watch day 3 and try to zoom and catch up. Okay, so that's what we're going to do. Don't worry, I'm not leaving y'all with nothing. I think it's in his best interest not to testify, because if he testifies, he's going to hang himself. Just saying.
We don't have any objections or additions.
They look good. Okay.
Yes, sir.
State's still looking over the instructions, right?
And so what we're doing right now is one of the most important parts of trial, which is jury instructions. Believe it or not, jury instructions can win or lose a trial if they're not properly done. Thank you for coming, letting me know, Deborah. Thanks for hopping in. Appreciate you so very much. I did send you a message in Discord if you felt it. You just talks.
Of course, one of the advantages of doing this too is if there are mistakes that are catch in the instructions orally, I'll correct them, and then I'll correct them in writing so that they get a perfect copy. It's actually better in that regard. So as I read along, does anyone want a hard copy of the instructions finalized? Okay.
Hey Google,
that.
you.
What I'll do tomorrow too is, it's my normal practice in reading the instructions to explain the verdict form. I won't do that. I'll read them the verdict part, but I'll explain the verdict form to them after your arguments tomorrow before they go back, because it's normally, that's the purpose of that. You're about to go back and deliberate. Also, submitting case to jury, I should probably read that tomorrow So I'll just stop at single defendant, multiple counts. Tomorrow, I'll reiterate verdict, single defendant, multiple counts, in submitting case to the jury, explain the verdict form, and then send them back tomorrow. But at least they'll get the full instructions on the law at this time.
Okay, guys, sorry, that was mom.
Here's a
I do
copy
have a hard
for
stop at 4:15 today.
each side,
So,
hard copy.
most of it
And let's bring out the jury and I'll
filed
instruct them.
this afternoon.
Do ask those who are here in the audience, you're free to remain, but you must remain during the whole instructions. I don't want people coming in and out of the courtroom while I'm instructing the jury on the law. You're doing that tomorrow. Unless you just want to forego your closing arguments altogether. No. Right. I think I'd urge you to do your closing argument.
So this judge is going to, not all courtrooms do this, but I appreciate the ones that do, to limit the entering and exiting of people when the instructions are being read. I really appreciate that because it's very destructive. Hello, Luca. Member for 1 month. Hello. We missed you, Luca. We missed you. But I'm so blessed to have you back today. June, double check.
All right, the jury is present. The state has rested its case at this time. Does the defense also rest its case at this time?
The defense rests, Judge.
Ladies and gentlemen of the jury, both sides.
There is no defense. Zero defense, which I don't think it's cool, but it's risky. It's risky. They do not have to put a defense on. There is no defense to put on, I think, in this case.
Have now rested their case. What we would normally do at this time is do the closing arguments, and then I would conclude the trial with the jury instructions and have you deliberate. We're going to depart from that and use an alternate procedure, which is perfectly fine and legal and perhaps better for the situation. What I'm going to do at this time is instruct you on the law as agreed upon by the lawyers, and then they're going to make their closing arguments to you tomorrow morning, after which you'll begin to deliberate on the case. The advantage of this is you'll have heard the law already, as an advantage to you understanding their arguments to put it into context. But please remember something I instructed you on throughout the trial, which is do not form a definite or fixed opinion on the merits of the case until you've heard all of the evidence, the arguments by the attorneys, and the law as I instruct you. And it was stated in that sequence because that's normally the sequence. So you're going to hear the law, but don't form any definite or fixed opinion until you've heard the attorney's arguments tomorrow. And of course, until the time I send you back into the jury room, don't discuss the case with anyone, including your fellow jurors. I suppose what I'm saying is the fact that I'm going to instruct you on the law now is not an invitation to start your deliberations, which are actually mentioned in the instructions, that you don't start your deliberations until tomorrow after the attorneys make their final arguments to you. Also, I'm going to be reading the instructions to you. Tomorrow, after the arguments are made, these instructions will go back with you into the jury room, and I'll have a copy for each of you individually for you to refer to should you need further reference to the instructions during your deliberations. And members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Jose Soto-Escalera, the defendant in this case, has been accused of the following crimes. Count 1, first-degree murder with a weapon. Count 2, first-degree murder of an unborn child. Introduction to homicide. Jose Soto-Escalera is accused of first-degree murder in counts 1 and 2. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Tania Wise and her unborn child were killed by Jose Soto-Escalera, you will then consider the circumstances surrounding the killing in deciding if the killings were first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before Jose Soto-Escalera may be found guilty of first-degree murder with a weapon, first-degree murder of an unborn child, or any lesser included crime. Count 1, first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tania Wise is dead. 2, the death was caused by the criminal act of Jose Soto-Escalera. And 3, there was a premeditated killing of Tania Wise. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Jose Soto-Escalera did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death. And Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tania Wise. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. If you find that Jose Soto-Escalera committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of first-degree murder. Count 2, first-degree murder of an unborn child. To prove the crime of first-degree murder of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise. And 2, Jose Soto-Escalera's killing of Tania Wise was first-degree murder, as I have instructed you in count 1. Unborn child means a member of the species Homo sapiens at any stage of development who is carried in the womb. When there are lesser included crimes, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which Jose Soto-Escalera is accused, there may be evidence that the defendant committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes of first-degree murder with a weapon are second-degree murder and manslaughter. The lesser included crimes of first-degree murder of an unborn child are second-degree murder of an unborn child and manslaughter of an unborn child. Second-degree murder, a lesser included offense as to count 1. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tania Wise is dead. 2, the death was caused by the criminal act of Jose Soto-Escalera. And 3, there was an unlawful killing of Tania Wise by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jose Soto-Escalera did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tania Wise. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder. If you find that Jose Soto-Escalera committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of second-degree murder. Manslaughter, a lesser included offense as to count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tania Wise is dead. And 2, Jose Soto-Escalera intentionally committed an act or acts that caused the death of Tania Wise. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Jose Soto-Escalera committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed manslaughter, but you're not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of manslaughter. Second-degree murder of an unborn child, a lesser included offense as to count 2. To prove the crime of second-degree murder of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise. And 2, Jose Soto-Escalera's killing of Tania Wise was second-degree murder, as I have instructed you in count 1. Manslaughter of an unborn child, also a lesser included offense as to count 2. To prove the crime of manslaughter of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise. And 2, Jose Soto-Escalera's killing of Tania Wise was manslaughter, as I have instructed you in count 1. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not, let me start over. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. And counsel, I'm striking that next sentence in this particular case. Whatever verdict you render, start over with that sentence. Little tongue twisters here. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proved beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And tomorrow, after the arguments, I will show you the verdict form and explain it to you before I send it back with you for your use. Single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The last instruction is submitting the case to the jury, which I'm going to do with you tomorrow. So after the arguments are concluded, I'm going to reread to you the few of the last pages here before I submit the case to you. That concludes the instructions at this time. Tomorrow we will reconvene at 8:45 in the morning, just as we did today. Remember, I cannot overly emphasize, you have not heard the arguments of the attorneys. Don't form any definite or fixed opinion about the merits of this case at this time. The same rules of that govern your conduct remain in effect. Of course, in abundance of caution, please remember, avoid any exposure to any extrajudicial information. Don't talk to anyone. Don't do any research about the case or the people or the issues involved in the case. To be sure, you can find your consideration of this case only to the proper evidence and nothing else. Avoid all of the media coverage of this case. With that, enjoy the rest of your day and your evening, and we'll see you tomorrow morning. Please leave your notes on your chairs. Jury has exited. Before we break, let's take a look at the verdict form as well, just to be sure there's no objections to that.
You might as well get it all down. In my humble opinion.
Oh, yeah, I wanted to take out the form as to count 2. The state had put in a weapon, which doesn't apply to count 2, so I'm going to take that out. You remember that? Okay. And I also put unborn child in the language as to count 2, which fits the charge. It just said first degree murder. It didn't say unborn child. So I have that as the count 2. And it is still September. So that's correct on the verdict form, right? And so right now the verdict form says what was that? We, the jury, find Jose Antonio. I'll get rid of the Antonio.
That's all right. Yes.
Do that also on the top there. Verdict form. We, the jury, find Jose Soto-Escalera as to count 1, select only one, guilty of first-degree murder as charged in the indictment, guilty of second-degree murder as a lesser-included offense, guilty of manslaughter as a lesser-included offense, or not guilty. If you find the defendant guilty as charged or guilty of any of the above, there's an error there. Above lesser offenses. I'm adding a word there. You must next determine if any of the following has been proved beyond a reasonable doubt. Check yes if proved beyond a reasonable doubt. Check.
We will be going into the drugged husband bedroom trial, Herbert Willie. We'll be doing that when this is done. So we still have trials today. We're double dipping. I kind of sensed this was going to happen.
No, if not proved beyond a reasonable doubt. During the commission of the offense, the defendant did carry, display, use, threaten to use a weapon, or attempt to use any weapon, yes or no.
Okay, let me catch everybody up. The state rested. The defense rested with no witnesses, no testimony of any witnesses, including the defendant himself. He chose not to testify in his behalf. So they have, the defense requested to do the jury instruction for closing arguments. So they have done that. Now they're working on the verdict form. And then the closing arguments will be first thing in the morning and go to verdict. I suspect we will have a verdict within a few hours tomorrow. I don't expect this to take too long, but God only knows what happens in a jury room. I could be wrong. Get back into court.
To select only one. Guilty of first-degree murder of an unborn child as charged in the indictment. Guilty of second-degree murder of an unborn child, a lesser-included offense. Guilty of manslaughter of an unborn child, a lesser-included offense. Not guilty. So say we all. This blank day of September 2025. 4 persons. So That looks good. I'll print out a few copies of that to give to you all and for myself here. And anything else before we break from the case? From the state?
And my only request for tomorrow would be to have it maybe a 5 or 10 minute bathroom break after the defense finishes.
After the defense part? Well, that reminds me of another issue. So what we should do for the bailiffs, take the lunch order of the jury as soon as possible, because they're going to be here lunchtime for sure. Are we still using roots or whatever? Oh, there you go. That's less offensive to the jurors than the other miserable food that we were offering them, like some kind of sprouts and something. So that's good. Let's take their order so that it's there and we get the lunch, because it's going to be right about lunchtime that we're going to submit the case to them. And as far as the bathroom break, that's perfectly fine. In fact, Miss Minton, if you want one after they get finished too, I'm just kind of giving you a wink and a nod, and we'll do that as well. All right. And if there's nothing else, how about this? Maybe this is a good time to check over the evidence to be absolutely sure there's nothing going back that shouldn't.
They've already locked it up.
Oh, okay.
I mean, open it back over, you can look in the clock, because the clock is really, and it's not gonna take that long. I can pull it out.
There's not that much.
Just to avoid calamity, the items that are not fully admissible, you know, that we've done those, I forget, 160, exactly,
170, 183.
which are not going back to the jury. But if they did, is there any request for a laptop to go back to view other stuff? There's not. So we're kind of doubly safe. Even if it goes back accidentally, they can't view it anyway because they don't have electronic.
Well,
no,
I take that back. The defendant's interview.
And
The defendant's interview.
surveillance videos are going back there.
Right. So we need to
will
be
have a
extra
laptop.
cautious to make sure that those don't go back. And the other item that's not, just make sure the other items that are not into evidence do not go back into the jury room, because there's several that were marked that are not into evidence, right?
Yeah.
I'm going to strike that. You all caught that? It was good, Johnny, on the spot. The sentence that I said was, I decide the sentence. Well, no, well, Judge, why do we spend 2 weeks in death qualification? Yeah, right. That was a good catch by me. I'll strike that and reprint the instructions for myself and for the jury. All right, and then we'll be adjourned until tomorrow morning at 8:45. Thank you.
Oh, I remembered that. I remember that, guys. I am making a new, y'all have a choice. We can just stay here and go live and do what I did yesterday, which was run this banner at the end. Instead of creating an entirely new live, or I can create a whole new live. I'm going to leave that up to you guys. Because I have to create a thumbnail and do all the transferring of all the information. So I will do it if you want to do a new live, or we can just stay here. This is what I call a bonus trial. So I'm going to leave that up to you guys and see what y'all prefer to do. So voice your vote and down below, please. Vote down below. In the meantime, I'm waiting for my image to upscale. I gotta trying to create a new thumbnail. See what happens. But we're done. And I guess my question to you, I could do a quick poll while we wait for everything to happen. A new one? Yeah, I knew you were going to vote that, June. I knew you were going to vote that one. I'm going to create a quick poll. Give me a second. I don't know why he dropped the Antonio. I don't know why he dropped it. Said I wanted a poll, not a question.
Okay, polls started. It's just going to take me a second, June. I see your vote, Miss June. I'm waiting on others to hop on in. We do have the poll started. Let me get this up. Trying to quickly get a thumbnail thrown together. I don't like doing them this fast, but I shall. I shall. Will make you happy. I shall do it. This is a really fast one I'm doing here, guys, so it will not be my best work. Will not be my best work, but it will be there. In the meantime, I'm waiting for your vote. Huh. How many people voted so far? 4 votes, 100% guilty. Yeah, that's kind of an interesting I am trying, y'all. A hot minute. It's always fun doing things on the fly, y'all. Oh, someone said share it. Oh, okay. I'll share my screen. I'll share the screen. Somebody. Somebody wants to know how I do this. They find it entertaining. Okay. Let me go here so y'all can see how I do this. So this is the trial we're going to be watching. Change colors. I don't like having all the same fonts, same colors. So let's do some changing here. Everybody go take a potty break. Go take a quick restroom break and get yourselves ready because we're going to go into this court in a minute. There we go. Why can't I size it? Oh. Where are comments? June, are you the only one who cares either way? Are you the only one that cares either way? This is one thing that I actually love to do. Love doing this kind of stuff. It is one of my favorite things to do. There we go. I am so into this. I is, y'all. So now I got to go find my picture. So one thing that I find interesting is the fact that they actually did not put on a defense in this case. I would expect some kind of defense to come up. I guess once you hear the all the evidence and those transcripts, oh my gosh, y'all, the transcripts were just absolutely horrendous. I really felt bad for the mother to have to sit there and hear those transcripts. I mean, come on now, y'all. That's horrible. That is absolutely horrendous and horrible. That poor mother had to sit there and listen to the transcripts. Hard for me to see on the side of what was going on with her, with all of this. I really think at some point, sometimes it's best if the mother or the family steps outside. One, but I ask, I'm not asking that. Maybe Thank you. And thank you. I really do feel bad for the families having to sit and listen to all that. Okay, this is good enough. Whoop, don't want to do that. Almost into the live stream. This is good enough for now. Get that downloaded. We will go ahead and let me get the live set up. And since Miss June voted for a new live and nobody else is voting. Okay. All right, guys. Give me a split second. We're going to end this live. We'll create a new live. It is all a fury. What are y'all doing this weekend? I am going to be unpacking. I had someone say, so how's the packing going? Well, it's not going. I unpack a few little boxes here and there a day, and it is not fun. Not fun in any way, shape, or form. I hate moving. I moved in the military every year of my life until I was a freshman in high school. It was not fun. Not fun at all. What time is it? 10. We're going to go 11. I'm creating a quick live, y'all. It is so much fun to move. I love the old style of moving in the military where you walked in and okay. Where they walked in and they packed everything up for you. They labeled everything. I mean, everything was so beautifully packed. All your glasses, each glass, each little. It didn't matter if this little pair of scissors were made of glass, they would bubble wrap it. Their packing was impeccable, and I absolutely loved their packing. And then you go to the new place, and then all of a sudden you go into each room. The boxes would be neatly stacked, very neatly stacked, and it was amazing. It was amazing, and I miss that kind of packing. I do. I miss that kind of packing. Why am I creating live stream? What? What? How is the thumbnail that big? That's weird. Because my thumbnail's too big. Let me edit this. That is strange. I don't know why it did that, but it did. We'll do this now and see if that helps. Thumbnails to, I don't know why that was a problem. That was weird, y'all. Very weird. June. There we go. All right. I got to redirect. Save changes. We're good to go, June. Are we good to go? Go over here. All right. We're going over. They have gone over the depositions. It was a little unusual. Let me recap today. We finished with the defense tidying up and cleaning up all their loose ends. They did a lot of identifying of documents and witnesses and people in videos. They had a transcriptionist and Spanish to English transcriber go over all of the work, and they did a little bit of reading back and forth, entering it into evidence. However, the one thing that jury needs to know is that they are not going, and I repeat, are not going to have those with them back in the deliberation rooms. They will not have that evidence. The transcripts will not be going back. So, yeah. So that's going to be something that I know they wish they had, but they're not going to have. So give me a split second. I'm going to go over here. I'm going to start the live And then I will hang up on this live. You're going to see a little bit of both go. Didn't mean to do that. Not mean to do that. That was weird. Okay. So tomorrow we'll be closing arguments and hopefully we'll have a verdict before the weekend. I sure would hate to have to wait for the whole weekend. Okay, guys, I'm going live over. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.